Yes. My Lord. So, if we just step back for a moment and just sort of see where we are and what the real issues are. So, under clause 8.1 of the deed, the trustee is given the power to add any person or class or description of persons as a beneficiary for the purposes of the declaration. So, on its face, one can see, just as a matter of language, or if one asks oneself, what is the settlor intending by giving that power to the trustees? We would respectfully suggest that it is clear that what the settlor intends is to say to the trustee, during the 100 years of this trust, I have nominated at the beginning my children an issue, but I'm giving you the power, trustee, to change that, to add new people, to take people away, as you see fit, because things may change. Now, of course, what the settlor expects in that, and I'm using settlor here to include the economic settlors, what they expect is when you exercise the powers, on our case, that you will take account of what you think I would have done. I'll be dead, in all probability. I'm a man in my late 70s, early 80s, or at least I may be dead. As it happens, they weren't in 2005, but YC died a couple of years later. YT died, I think, in 2014. But in any view, this is going to extend far beyond their possible lives. And we say that the purpose of this, and this is the dividing line, was to allow the trustees to take account of any change of circumstances as they saw, and to decide who should be the appropriate beneficiaries of the bounty. Now, what's said against us is two things. It's said by Winston that there's a so-called substratum rule, which is a species of the proper purpose rule, and any alteration to the substratum is improper. Tony says, as I understand it, that the purpose of all powers in a trust instrument, even powers of addition or exclusion, is to benefit only the individuals identified in the trust instrument as beneficiaries or objects, including anyone who's been added in as an object. But the rider to that, he says, as I understood the submissions this morning, unless you expressly say so. Now, on that submission, the position actually is, well, what does Clause 8 say in context? Is it saying that you can add, the purpose of this is to allow you to add people and remove people to take account of change of circumstances? And just stopping there for a moment, in the normal situation, if one thinks about it, and just read this as a matter of the language, if the trustee adds someone, that is to the detriment of the people who are existing beneficiaries, because there's someone else who is potentially going to share in the bounty, and indeed that person may get the entirety of the bounty. So what is said is, well, no, because you only add somebody who benefits existing people. Now, we would suggest, as a matter of obvious construction of a deed such as this, where you see a power of addition and exclusion, that the trustees are constrained. I think there was a question, well, aren't there equitable obligations that constrain this? The equitable obligation is that you have to use the power for the purpose for which it was given to you, i.e. the purpose that the donor of the power intended. But that doesn't mean that the donor, and I think as Mr. Wilson actually accepts, can't say, I'm going to give you a power to add people, remove my existing beneficiaries as you see fit. And so the question is, and when one comes to construe this, is there something in, as it were, the background or the law which says, well, you have to start from a position that a power of addition, and that's what we're concerned with.
Sorry, were you just accepting that there is some equitable constraint on the use of...
We've always accepted that there is an equitable constraint in the sense that there is a proper purpose rule. And the question is, what is the purpose? I mean, we say, just to go back a stage, my lady, we say, on this case, the question gets answered as a matter of construction in this sense, that if as a matter of construction one comes to the conclusion that any means any, and you were entitled to add any, then it's difficult to see that the proper purpose rule has any impact, because it's not being said that the trustees here were acting for some ulterior purpose. What's being said here is that you had no power to do this. So the distinction between, if you remember the Eclairs case, in Eclairs, the point was that the company had the power to, I think, to request information. So there was nothing wrong with doing that. But they had to do it because they were actually, I'm paraphrasing it all, but it's genuinely about seeking information. Whereas actually they weren't genuinely interested in information. What they were interested in was blocking somebody's right to vote. And so that's what Lord Sumption was looking at in that case. In our case, it's very important. This isn't a case about saying you trustees had some motive that was improper here. What they're saying is, no, as a matter of the power that you're given, you are not allowed to add anyone on the different, on Tony's version of the case, who doesn't benefit someone who is already either a Schedule 3 beneficiary or a Schedule 2 beneficiary.
So can you pinpoint precisely why someone would even specify the beneficiaries in Schedule 2?
Yes.
Insofar as you're effectively, as I understand it, saying that as a matter of construction, you're trusting the trustees to add whoever they think appropriate. So you might say, why are we even having any reference to children of the Wang family?
Well, the answer to that, my lord, is that this isn't, they're not setting up a trust where they're saying simply to the trustee, this is a trust where I want you to hold the property, and you've got powers of disposition, and you can benefit anyone in the world, and I've got no consideration. The purpose of the trust, as I said before lunch, was, the reason they named their children and beneficiaries is that at that stage they did anticipate their children and their children and the issue of the children. They anticipate them receiving the bounty through the trust and remaining the beneficiaries with a capital B. But they're saying, well, the circumstances in which I'm doing this might change, and so I'm leaving you, trustee, with this power of addition and exclusion to decide in due course whether things should change. So you take the situation we discussed before, where you have a sort of, you don't have this complication of incentivizing. You have children, you have a Red Cross trust. Red Cross is the default beneficiary. You have the class is actually like in, well, let's say you actually identify your children. Very often you won't. You identify your two children, but you give the trustee a power of addition and removal, and he already has the power to decide how much anybody should get, and you say nothing more other than the trustee knows from the background that you were interested in people who work hard, earn their living, behave in a reputable way, and so on. And after you're dead, the trustee learns that your children are leading dissipated lives, and if they got any money, are likely to spend it on inappropriate purposes. So the question for the court is, where you've given this sort of power, does the trustee have the power to say, well, I don't think the settlor, if he knew what was going on, that he would want the money to go to those two, and I'm going to now add someone else who I know he was keen on this charity or keen on this person, and they're going to get the bounty. That's actually the question. Firstly, can you do it? And as I understand it, it's not disputed, at least by Tony, as I understood it, that you can. And the question is, have you done that?
Is that different, then, than a discretionary trust for the whole world except X, Y, and Z, with clear expressions of wishes that money should be given to the children?
So if you have a trust which says you can appoint anyone in the world except for X, which is the trustee, and you have a letter of wishes saying the people I'm really interested in benefiting are my children, well, in my submission, there's absolutely nothing wrong with that sort of trust. And if you don't have a letter of wishes, there's absolutely nothing wrong equally. The trustee, in exercising his powers, will be expected to take account of what he knows of the settlor, his knowledge, including inherited knowledge. And I'll show you that in Mr. Justice Templeman's judgment.
But suppose you seem to be moving towards a situation where the ability to use Clause 8 to add the WFT is contingent or follows on from a change in circumstances which makes it inappropriate for the original Schedule 2 beneficiaries to still receive the bounty. But suppose there'd been no change of circumstances between 2001 and 2005, but the trustees had simply, after proper deliberation, decided to add the WFT and transfer all the money to that.
Yes.
Was that within their powers?
Yes. No. The answer is, the reason the answer is yes, my lady, is this. You give the trustees the power because you anticipate there may be changes of circumstance and you want to give them a very broad power. Now, if there is no change of circumstance, they still have the power, and there may be reasons why they come to the conclusion this should be done, but whether they've exercised their power properly will depend on adequate deliberation. Yes. So, for instance, taking your ladyship's example, if in 2005 the trustees, let's assume there's no change of circumstances, and let's assume the settlors were dead, so you had no further information, and the trustees just say to themselves, well, you know what, this was to incentivize the kids to look after FPG. Well, frankly, what's the point of that? I think we should just give it to FPG, not to FPG, but to the Wang Family Trust. Now, then there would be a question as to whether doing that you are acting properly, taking account of what you knew about the settlor's intentions for all of this. Because it might be said, well, that would be just perverse if there isn't a change of circumstances to change things.
Well, you seem to be pushing the whole thing on to the second of the three Pitt and Holt criteria on the basis that everyone's agreed that that's not something that we can investigate.
Yes, well, I'm pushing it off. I say I accept that is an issue for trial. Everybody accepts that's an issue for trial as to whether the trustees did in fact properly deliberate. The question for today is whether they had the power to add GRT. And I mean, if one stands back from this, what is being said is there's no power as a matter of construction, or somehow there's no power by some species of the proper purpose rule by saying this power can only be used to benefit the existing class of either beneficiaries or objects. Now, we say as a matter of construction, that's why it is actually quite important that one recognises the analysis that one needs to go through. One does need to ask oneself, as a matter of construction of this deed, is there any restriction in Clause 8? Now, if you say to me, well, or the court says, as a matter of construction, Clause 8, although it says you can add anyone in the any person, etc., firstly, if one says no, it doesn't allow you to add a person acting in a fiduciary capacity, then they didn't have a power. We say that's wrong. If your ladyship says, well, no, but it didn't allow you to add someone who wasn't related to the Schedule 2 or Schedule 3 beneficiaries, frankly, it doesn't say that, and I would say that it's just it can't bear that meaning. But obviously, you're the decision makers, not me. If that's what was said, then the answer would be there wasn't a power. But unless, if you can't get there as a matter of construction, the question is, where do you get it from? And in our submission, that is where you then come, when you apply the proper purpose rule, in fact, in this case, if you've decided as a matter of construction, this was given to the trustees in order to enable them to deal with any circumstances that arose, and because the settlor trusted them, it's very difficult to see in our submission that you can then say, well, I cut it down, and that the settlor intended that this should operate for the benefit of the existing beneficiaries. Now, the submission that's made against me, and this is really what I want to come on to, is that the settlor, according to Tony, is taken to intend, and that's really the submission. You see that in his submissions, in his written case at paragraph 152, and perhaps we should look at that. It's at 1853 of the bundle. Yes, 1852. Yes, paragraph 152. Now, he says, in the second sentence, a settlor who sets up a typical family trust, leave aside what is a typical family trust, must, with wide discretionary powers, and this is the important part, is simply taken to intend to confer benefits on those persons who are specifically identified as beneficiaries or objects. When settlers represent that named persons are intended to benefit, they should be taken to mean what they say, and the trustees' duties are limited accordingly. But what, of course, that sidesteps, no doubt deliberately, is what about a power of addition? Why, when you have a power of addition, in very broad terms as we have here, one has to ask, why does the law say you, settlor, are taken to intend to confer benefits only on the persons named, so that the power of addition can only be used to benefit them, when we would suggest the purpose of the power of addition was to add, if circumstances arise, other people who may not have any connection with the existing beneficiaries, but are people who are appropriate recipients of the settlor's bounty as the trustees see it.
Well, one thing that I'm struggling with is that all that you say would have been met and would have been possible if the trust had been for anyone in the world apart from the trustee. And then all that you say would be applicable. Trust the trustee to do more or less what the settlor might have wanted. But this trust structure seems very deliberately to be at an intermediate stage with the rather elaborate procedure of having beneficiaries within Schedule 2, and you can add beneficiaries, but you have to do that before you trigger the various powers under it. And so I was just wondering whether it might not be said that the reason that structure has been chosen is specifically to focus the bounty on the beneficiaries from time to time. And that is different from a trust for all the world, not least because there will be the obligation of proper consideration before anyone is added as a beneficiary. So if you like, the trust structure is aimed at reconciling two things. Yes, flexibility to accommodate the unknown future, but at the same time the bounty down in some way which is more constrained than just saying it can be anyone in the world.
Isn't the answer to your Lordship's point is surely this, that, and I don't think it's actually, at the end of the day, very different to the example that my Lord Burrows gave. In your example, my Lord Sales, you start off, there's no question, and I don't shrink from this, that the initial beneficiaries designated are the children and issue. Now, if you're going to, add somebody else as a trustee who is not the children and issue, you've got to have a good reason to do it. And so there will either be a change of circumstance or some other good reason, but you can't just do it, as it were, because it's a Wednesday and you think it's a good idea. So as a starting point, you've got to consider why, you would have to consider at the due deliberation stage, why am I going to add somebody? And that doesn't matter whether what you're talking about is a widow or partner or something like that, some sort of extended member of the family, or you're saying I'm going to add somebody because I think this lot no longer fulfill what it was that the settlor was interested in.
Right, but why bother with all of that? Because if you had a trust just for all the world, apart from the trustee, you could consider those things as well.
Well, the answer is why. I mean, that is true in one sense, but it's just simply that is your starting point. I mean, in all of these cases, and for instance, where you see a trust which says you have a power for anyone in the world, there is usually some understanding, whether it's in a letter of wishes or knowledge of the background, as to who the settlor actually intends. It would be very unusual that the settlor intended the trustee just to benefit anyone that he felt like it. You're always expecting him to take account of the views of the settlor.
Right, but I think what I'm pressing you on is that your argument seems to collapse down what seems a very carefully framed trust structure in the deed into a completely general trust, where the beneficiaries are anyone in the world apart from the trustee. And just so that you understand my concern is that is to sort of downgrade the significance of the structure that has actually been put in place in the deed, which I accept is flexible, is intended to be flexible, but is not the whole world.
No, well, it is. Firstly, I mean, there's more than one way of achieving the same thing, but in this trust, I mean, there's a danger of overstating it with respect. The children and issue are stated to be the beneficiaries within 1.1, subject to the exercise of the Clause 8 power. So the starting point is that the settlor is saying when he designates them, I would suggest, that I'm not designating them immutably and for all time, because Otherwise, what does subject to the exercise of the Clause 8 powers means? It's recognising that they may be supplanted, and I'm giving the trustee the power to do that. But the background to this, plus designating them at the beginning, means that the trustee isn't going to lightly displace them. He will need good reasons. It may be because there's a type of change of circumstances we've spoken about, or something else. But absent a change of circumstance, it may be difficult to show a good reason for changing things, for adding somebody. So you trust the trustee, but you trust him to act, as it were. It's a bit like looking after somebody else's children and being in loco parentis. The trustee here is you're hoping that he's going to stand as if you had your thinking in your shoes and will do what you want. But the trustee knows that your starting point was that this was to benefit my children an issue, albeit in a particular way. I think that's very important. The particular way being to create this incentivization, not per se simply to give them, as it were, bounty. It wasn't just, this wasn't the typical family trust where somebody has made a lot of money and is saying, well, I want that money to trickle down to my children and future generations just as money to benefit them. It was for a particular purpose. And picking up my Lord Sir David Richards' point, I mean, whether that is a sensible thing or not, or workable, that's what the evidence shows that the genesis and the intent behind all of this was.
But if the settlor had intended that the trustees should be able to do what they have in fact done, wouldn't it have made better sense to not have Clause 23 and to make the declaration revocable? So
well, no, because
if everything had changed so that one didn't want these second schedule people to benefit at all or anybody like them, you just revoke the trust. What would have been wrong with that?
Well, there's a lot wrong with that. The settlers were very old then. They're not going to live for 100 years.
But they're not the ones making the declaration. The declaration is made by the company. The company goes on.
Yes, yeah, but the problem is if you... Well, I'm not quite sure. Then I'm maybe not understanding your ladyship's point.
Well, it seems inconsistent to have an irrevocable declaration of trust with these beneficiaries, and yet you say have a power of addition which in effect enables you to jettison all these beneficiaries and have a completely new set of beneficiaries.
Who's the you in this? That's the difficulty.
The trustees. They are the ones who declare the trust. The original trustee, which is a continuing body.
But when you say it would have been, I mean, the trustee is just a trust company that's established for this purpose.
Well, yes, everything is just this, just that, but it is actually, the declaration of trust is by Global Resources Private Trust Company Limited.
Yes.
So if the settlor had really intended that the trustee should be able to jettison all the beneficiaries who are included in the second schedule,
yes,
and have completely new ones, why wouldn't it have been better and clearer to say, well, on a change of circumstance, you can revoke this trust and make a different declaration?
But there are a number of answers to that. Firstly, I mean, the fact you haven't done something in one way doesn't actually tell you anything about the way you have done it.
Well, it may do.
Right. I mean, but the purpose of this is not to revoke the trust. The trust wasn't revoked by reason of adding Grand View as a beneficiary.
Well, but in effect it was. So why shouldn't you do it in a more straightforward way? Well, if that's what you think the power is.
The thing is, though, the part of the problem is that one's, with respect, falling into the trap of assuming that the settlor, and I'm now talking about the economic settlors, that they are anticipating anything that may arise in the future. So that your ladyship's question is assuming that what they anticipate in 2001 when they set all of this up is that what may happen is that we may want to add a new beneficiary, which is going to be GRT, and we're going to distribute the funds to them. Now, in 2001, no one suggests the set laws had that in mind. All that they had in mind was giving the trustees a very broad power under Clause 8. Now, so saying, well, in the events that happened, well, wouldn't it have been better if you'd revoked? I would say no, but that it doesn't. I would suggest it doesn't actually advance the debate really, because what you're asking yourself is what are the constraints on the power of addition when it was created? And that question is dependent upon whether one says, I mean, you come back to the same point, was the power of addition limited to benefiting the existing beneficiaries and objects, or is it meant to actually not take account of their interests because it's meant to allow you, if you think it appropriate, to add new people which may not be in their interests?
It may not be in the interests of some beneficiaries, but may be in the interests of others. I'd have thought that you just need to find one beneficiary.
Well, that's the argument. That's the argument that's made, but there could be that's said to be the limit, but the constraint. But I mean, if one of the things that's odd about the argument, and I think Lord Sales, you reflected on it this morning, on this argument, you can add. So let's say one of the children has an interest or moral obligation towards Save the Whale or some such charity. You can add on this argument Save the Whale as a beneficiary, as an object. Then, having added Save the Whale, then that would entirely, on the argument that's made, transform the trust, because it's previously a trust which is only for the benefit of the children. Now that you've got Save the Whale in, you can actually distribute all the money to Save the Whale, because that would be exercising the power in the interests of Save the Whale. Or you could add a whole lot of other charities which were related to Save the Whale. Now, what we suggest is that shows that it is unlikely that anybody intended the clause to operate in this way, whereby when you are adding, you have to take account of the interests. I mean, you can only do so for the benefit of the existing beneficiaries. And perhaps it's worth, I said we would look at Schmidt. Can we go to that? Because it's quite an interesting case in relation to what we're currently debating.
I'm so sorry to interrupt you, but just to come back in relation to that. It might be said that whilst it's true, as you say, that one might proceed quite quickly to a situation where the class of beneficiaries has been expanded to include a charity or a range of people who then have a range of people associated with them, and you move away from the initial focus on the family, but that it's still going to proceed in somewhat incremental steps, and you're always going to have the controls which you yourself emphasise about trust the trustees to act properly. So, I mean, really, what I just wanted to put to you is a variant of what I was putting to you before, which is, might it not be said that the structuring of the class of beneficiaries in this way, whilst allowing for adaptation to the future and the unknown future, still provides a greater degree of focus on the family, which was the original focus, and it's an incremental extension from that, rather than just starting at the other end and say, this is a trust for everyone in the world apart from the trustees.
Well, if you... I'm not sure necessarily we're disagreeing. if you started, but the part of the problem is in the real world, when you say starting with a trust for everyone in the world except the trustee, in the real world, that's not actually what happens. So that although the trust instrument may say this is a trust, or the powers can be exercised for the whole world, everyone except the trustee, the overwhelming likelihood is that the settlor, by one means or another, has communicated who he intends to benefit. So you're actually not in the only difference between that case and our case, so in one case, the settlor doesn't, in the trust instrument, list the children, but you tell the trustee, this is really meant to benefit my children, but the trustee has the powers of addition and so on to decide who should go in. Now, in that situation, he will still have to decide if he's going to add in people who are not the children, whether that is achieving the settlor's bounty. The fact that you started off in the trust deed saying it's the children in issue in our submission doesn't make any fundamental difference. It may mean when you come to your, all it means is as part of your deliberation, you are going to have to consider, why am I adding these people in? And if you're removing the existing ones, why am I doing that? And why is this something which falls within what I believe the settlor would want?
Mm. Well, if I may say so, that answer does seem to me rather to bring out that actually the thrust of your argument is to collapse this trust that we've got into a trust that simply said at the outset, this is a trust for everyone in the world apart from the trustee, and the trustees have a discretion who they can pick out to give the bounty to.
Well, subject to the fact, though, I mean, this is, the way your lordship's putting it is, I would respectfully say, not quite right, because it's ignoring. I mean, let's say that's what the trust says, but there is a communication from the settlor to the trustee that this is, I'm looking to you to look after my children, providing they behave themselves. That would be something the settlor, the trustee, would have to take into account. Now, your lordship is saying, well, it makes a big difference that you named as the initial beneficiaries, or the beneficiaries in the schedule, but subject to the exercise of the powers under Clause 8, the children in issue. Now, I accept the fact they're there isn't something that can be treated as irrelevant, and no one is saying it was, but it doesn't mean that the power of addition has to be exercised for their benefit. I mean, that's ultimately the question. We say the whole reason you have a power of addition is that you may not be exercising it for the benefit of those people.
Yes, but in the case, the first of your examples, where there's a trust, where it says it's the whole world, or as in the BT case, such person or persons, whether individual or corporate, whom the trustees may select. But there is a statement of wishes which is merely there to influence the trustees. There's no question of being able to mount an argument that the trust had to be exercised for the benefit of the people listed in the statement of wishes, because the whole point is that the trustees have to have regard to the statement of wishes, but they can ignore it. Where, however, you include in the trust deed a statement that these are the initial beneficiaries, it seems to me that you may at least open yourself to the argument, well, you have to do it, you have to exercise the power of addition for the benefit of these people, unless you're correct in your construction that the opening words in the power, which says that it's subject to, so the opening words in Schedule 2, where it's subject to any exercise of the powers under Clause 8, means that the people there listed are merely a subspecies of what is the whole world.
Well, I mean, my submission is that the whole point of saying it's these people subject to the exercise of the power in Clause 8 is identifying that actually they may well be displaced by the exercise of that power. That's why you've been given the power. This is just saying this is what the position is at the outset. This is the position that the settlors intend at the outset, but that doesn't mean that's what they intend for all time, and they've left it to the trustees to decide whether or not there should be a change in due course. But
I mean, you say it may well be displaced, but the structure of Schedule 2 and the cross-reference to Clause 8 is to, if you like, compel the trustees to consider whether to add someone as an additional beneficiary, which may be quite a significant hurdle if they're thinking back to what the settler wants and possibly having regard to a letter of wishes if there is one. And so one doesn't readily move to, oh, and it saved the whale and anything at all. It's a way, or it might be said, it's a way of maintaining focus, as I was putting to you before, on the family and with the potential to spread out a little bit, but incrementally, rather than to start with the whole world.
Where I disagree with your lordship, the starting point is fine. The question then is, once you get to consider, right, I'm going to add somebody. Now, do you consider, what you've got to consider is, why did the trustee give me this power? What was the purpose of it? Am I exercising it in accordance with the sort of thing that I think he would have wanted? The debate is, your lordship is saying, well, it's incremental, and when you add someone, that's got to be in the interests of those who are already there. And my point is, no, it hasn't got to be in the interests of those who are there. But when you exercise the power and you're thinking about adding somebody, you will take account of not the interests of the beneficiaries, but what the settlor wanted. And the fact that the settlor initially said, it's my children an issue, you've got to consider on this case, well, why am I now going to add someone who's not the children an issue? What is it that I think makes that appropriate? Now, the change of circumstances is the example. So going back to my point, if you said, if you had two children named and you have the Clause 8 power, and you find that the two children named are people who are likely are leading a dissipated life, and the trustee concludes that I doubt the settlor would actually want them to get the benefit of this, that is a classic situation, I would say, where you could exercise the power. Now, you're not doing it, it's in no way in the interests of those who are there.
Well, that's not a good example, because you might say it actually is in their interests to keep them on a tighter rein if they're, and accumulate the money until they sort themselves out. So I'm not sure that is a very good.
Well, that's an
I think what you
sorry, can I just say, because it doesn't seem to me that's a fair point. Sorry, I don't mean to interrupt, but that's just saying, well, on my example, you could have a reason why you think it's in the interests of those individuals. But let's assume they desperately want the money. They desperately need it. They've got creditors who are chasing them. And so, in one sense, it's really against their interests. But the trustee says, well, you've built up gambling debts and all sorts of things, and I don't think your dad would have wanted his money to go to that. And so I'm going to add someone else and distribute to them. So I don't think one can just brush it aside saying, oh, well, it will always be in their interests. There will be lots of situations in our submission where you would be using a power of addition to add someone, and that may be against the interests of the existing beneficiaries. And that's the question. Now, your ladyship may say, well, no, I don't accept Clause 8 can be used in that way. But that's with respect the question. And it's really, what is the basis for cutting down the language of Clause 8? As the Court of Appeal said, and Mr. Justice Smelly said in the case they referred to, any means any.
Yes, but any does mean any, in the sense that Clause 8 imposes no restriction on the identification of anyone who can be added, but it doesn't address, expressly at any rate, the purpose for which the power can be exercised.
And that's what
so any means any. It doesn't. as I'm presently thinking, get you very far.
Well, it gets you to the first step, which is that there is no constraint within
on the identification
itself
of anyone who can be added.
Yeah.
Yes, I agree. If it did contain a restriction, it would be a roadblock for you.
Yeah,
I think the word any is being relied on for too great a purpose here.
Well, you've still, my lord, I agree that the fact that any means any isn't the complete answer.
No.
You've still got to ask yourself, well, firstly you have to ask yourself, as a matter of construction of the deed, do I find anything which indicates in the deed itself that this power is intended to be restricted? And then if...
Well, I think it's slight. I would put it slightly differently. Do I find anything in this deed or in Clause 8 which would say that whatever the circumstances, you cannot add the Wang Family Trust as a beneficiary? Now, leave aside the particular arguments that Mrs. Talbot Rice raised on there. Just leave those on one side. It would, as it seems to me, be going too far to say that in no circumstances could it ever be proper to add the Wang Family Trust as a beneficiary. So to that extent, the word any is making clear that there is no restriction on the identification of the person who may be added as a beneficiary. But what I'm having difficulty in seeing is that it goes any further than that.
Well, that is the first stage.
Well, I agree it's a first stage, it's a sort of preliminary stage, but it's not telling you anything, is it, about the purpose for which the power can be exercised?
What it's telling you first, as a matter of construction of the deed, I mean, if one starts at trying to look as a matter of construction in this deed, you have a power to add anyone. Now, is there anything in the deed itself where it says that, which leads me to, and the set law is intended, as our approach to construction, the set law intends what the words mean. Now, I agree, you don't just take a clause out of in isolation, but if you look at the deed as a whole, you have to ask, what did the settlors intend by giving this power? Did they intend the power? I mean, that's why saying, well, any only takes you so far, it's looking at the clause as a whole, which gives them, the trustees, a discretion. Yes, they are subject to the proper purpose rule, but if I ask myself, well, is there some limit as to who they're entitled to add? My submission is there's no limit. So that then takes you to a secondary question, which I think maybe your lordship is saying, well, do I get a limit from something else which says that when exercising this power of addition, and this is the case that's made, that you're taken to intend that that power of addition must be exercised in favour of the existing either Schedule 3 beneficiaries or Schedule 2 beneficiaries as they are at that date.
Yes, and the word any doesn't really help you on that second question.
Well, I would suggest it does, because it doesn't restrict you to those people.
Well, no one suggests it does. Clearly it doesn't restrict you to the people identified in Schedule 2. And as I say, it seems to me that it's saying there is no limit on the identification of possible additional beneficiaries. But what I'm questioning is, what does that tell you about the purpose of this power?
Well, surely...
Because it's accepted that it's a fiduciary power, and equity requires fiduciary powers to be exercised for proper purposes. And at the moment, I can't see that Clause 8 tells you anything about. It does nothing to exclude the proper purpose rule, or really tells you anything about the proper purpose, does it?
Well, we're not suggesting the proper purpose rule is excluded, but what is the proper purpose rule is what one comes back to.
I agree.
And the proper purpose rule is to use a power for the purpose for which the donee gave it to you. And that then raises the question as, did the donee give the power because he intended to allow you to add people as you saw fit, depending on the circumstances, or did he intend that you could only add persons where that was in the interests of the existing Schedule 2 and Schedule 3?
And the word any doesn't help you resolve that.
Well, I would suggest it does, where you haven't specified in the deed itself that it is limited in that way.
But it is limited by whatever equity requires. And so that's really the question, isn't it? What does equity require in terms of limiting the purpose for which this power may be exercised?
Yes. In our submission, to cut to the chase, equity, if you take a power of addition, doesn't require that a power of addition in a trust deed can only be exercised in the interests of the existing beneficiaries. It's as simple as that. And could we go to first perhaps to Lewin at page 8290, which at page 8290 of the bundle, power of addition, and this is Lewin's view of it in the second sentence,
Which paragraph, sorry?
3360. A non-fiduciary donee will owe no duty to consider exercising the power, but trustees and other fiduciary donees will do so. The duty, this is about powers of addition, cannot, stress that word, be owed to the existing beneficiaries of the trust, as most of the trustees' duties are owed. For if that were so, it's hard to see how it could be exercised at all, and it must be owed more widely.
Well, sorry, just pausing there.
Yeah.
It's not that difficult to see how it could be exercised at all, is it?
Well,
I mean, your own argument accepts that there may be moral obligations of a beneficiary leading to add to the list of beneficiaries.
Well, it can't be exercised, save on that argument, in very constrained and limited circumstances.
Right, yeah, but I mean, in a sense, that's what we're debating.
Well, but I mean, your lordship is right in this sense. Is the power one which is intended to be capable of being exercised in a whole host of unforeseen circumstances to cater for whatever may happen in the next 100 years, or is it constrained that it can only be exercised in the interests of the existing beneficiaries? What Lewin is saying is that that can't be right, that it can only be exercised in their interest.
Yeah, but yeah. What I was picking you up on, they give a reason, but the reason isn't a good reason.
Well, sorry, what do you mean? Yeah.
I think this is the passage that...
Sorry, is the authority cited for that, this case actually in a different...
I was just going to say, I think this is the passage that Mr. Wilson said was just wrong.
Well, I mean, he does, but...
Yeah. I just wanted to identify
I think he does.
Yeah, so he didn't give us the page reference, but
yes.
I scouted through
I mean,
it.
the footnote is quite interesting at page 8291. You'll see they refer to the My Cam case and Shu Pak Nin, and then the Wong case.
Is that this case in the Court of Appeal?
Yes.
In
Then, in particular circumstances, the exercise of a power of addition may be for the benefit of one or more of the existing beneficiaries, as where a parent will benefit from the addition of a child for whom he would otherwise have to provide, perhaps on less favourable terms as to a tax, even when a distribution could be made to the parent for that purpose. But as a matter of construction, few powers of addition are intended to be confined to such circumstances. And I would ask you to also note the rest of 33060 and 33061. Now, can I take you to Schmidt, which we were going to go to before?
And can I just check, will you be coming back to these authorities that are cited here,
yes.
apart from Schmidt?
Yes, I want to start with Schmidt, if I may. And Schmidt is at page 2407 in the bundle. Now, the facts are important, so let me just explain. There were two trusts involved, the Everest Trust and the Angora Trust, although for reasons I'll come to, we're only concerned with the Everest Trust. The co-settlor, Vitaly Schmidt, was a senior executive of Lukoil, Russian oil company. He settled the Everest Trust on the 20th of June 1995, and that was a discretionary trust. The default beneficiary was a charity, and there was a wide power of appointment in favour of a class of objects, which included Vitaly and other Lukoil executives. And that's recorded at paragraph 16.1 of Lord Walker on page 2417. Now, Vitaly, it's important to remember, did not have a vested interest in the trust. He was simply an object of a power, like the Schedule 2 beneficiaries in this case. Clause 3.3, which is set out at paragraph 16.2 on page 2417, gave the trustees a power to add and exclude beneficiaries. On the 31st of October 1995, 4 months after the creation of the trust, Vitaly wrote to the trustee of the Everest Trust, saying that in the event that he died, he wanted Vadim, his son, to receive his share of the trust fund. But, of course, note, when he wrote that letter, he merely had a spes. He didn't have a share of the trust fund. He died unexpectedly in 1997. Vadim, the son, applied to the court for disclosure of some trust documents. Now, if you go to 2421 at paragraph 33, this is what was said about Vadim. In relation to the Everest Trust, the appellant in his personal capacity is no more than a possible object of a very wide power to add beneficiaries. The Everest letter provides clear evidence of Mr. Schmidt's wishes and confirms, as would in any case be fairly evident, that he may have a particularly strong claim on the trustee's discretion. But neither the letter nor any other document put in evidence any further effect on his status as a possible beneficiary. So what is significant about that is that it was perfectly legitimate, it would be a perfectly legitimate use of the power of addition to add Vadim as a beneficiary, even though that wasn't in the interests of anyone originally identified in the Everest Trust deed as a beneficiary or object, of course, Vitaly now being dead. So Schmidt and Rosewood is, we would respectfully suggest, entirely inconsistent with the proposition that a power of addition could only be used in the interests of the existing beneficiaries or objects, because what was anticipated, the reason Vadim was able to come along is that he was within the class of those who might expect to be added, but that would not be in the interests of those who then were in the class, which was a charity as the default beneficiary and the other executives of Lukoil. Now, Tony seeks to distinguish Schmidt on two grounds. He firstly says that the terms of the trust that the board was considering specifically provided for the share to which a deceased beneficiary had been entitled during his lifetime would be held on trust for the deceased's beneficiary's nominee. Tony says that at paragraph 59D of his case at page 1825. Tony is simply wrong about that. Firstly, the provision to which Tony is referring was in the Angora Trust, not in the Everest Trust, with which Lord Walker was concerned at paragraph 33. And you can see that because at paragraph 13 of Lord Walker's judgment, which is back at 2416, he quotes paragraph 4.2 of the Angora Trust, which provided this provision as to what would happen in death. But at paragraph 16 sub 3 on page 2417, Lord Walker said there was no equivalent provision in the Everest Trust. So that point isn't a basis for distinguishing this case. Secondly, even ignoring that local difficulty, Clause 4.2 in any event would have been inapplicable even if it were part of the Everest Trust, because it was concerned with that portion of the trust fund to which the deceased beneficiary had been entitled during his lifetime, but Vitali had no entitlement during his lifetime because the trustees hadn't exercised any discretion in his favour. He had a mere spes and he died before the spes could become anything more. So there was nothing, therefore, for the trustee to hold on trust for Vitali's son, nothing for 4.2, if it had been there, which it wasn't, to bite on. So the first basis for distinguishing the decision of the Privy Council in Schmidt is wrong. The second point that is raised is that the appointment of the settlor's son, it said, fulfilled a moral obligation on the part of the settlor. That's Tony's case at paragraph 59 sub D, page 1825. Now, if Tony actually means what he's written, that is a revealing concession, because Tony appears to recognise the trustee must have regard to the settlor's intention or to what the settlor might have wished to do with his bounty in deciding whom to add. We say that is entirely right, but of course inconsistent with Tony's case. If, on the other hand, what he means at 59D is a slip for a moral obligation on the part of the beneficiary rather than the settlor, the argument also runs into the ground because Vitali wasn't a beneficiary, so fulfilling any longer, having died, so fulfilling any moral obligation he might have had could not have advanced the interest of any beneficiary or object originally named. So in our submission, Schmidt is an important case for all sorts of reasons in relation to what we're debating, but it is entirely inconsistent with the thesis that all powers in a trust, like the one there, must be exercised in the interests of the beneficiaries or objects originally named or as existing at the date that you would come to exercise the power.
Am I right in thinking there wasn't actually argument about this point? I mean, you obviously have the very considerable authority of Lord Walker saying clear that the son would have had a strong claim on the discretion, but the point wasn't actually argued out. Is that right?
Well, I mean, you have Lord Nichols, Lord Walker, Lord Hope, Lord Hutton and Lord Hobhouse. So then,
very, very many very authoritative judges. But
no slouches.
But my question is, was it a point of contention that was argued out in the case?
The point of contention was the whole issue was whether he had standing. Did the son have standing to bring this claim at all? I mean,
well, he wasn't really bringing a claim. He was seeking to invoke the court's supervisory jurisdiction over the trust to order the trustees to give disclosure.
But did he have standing to do that? I mean, and the premise of the standing was, what is said at paragraph 33.
Yeah, I mean, that was really my point, that it seems to be assumed he is a potential addition as a beneficiary. And then that's the foundation then for the debate. And is that good enough to give you standing to get information or not?
That's what they decided in this case.
Yeah. But that is to suggest, as I was putting to you, that there wasn't actually debate in the case about the exact nature of the limits on the power to add a beneficiary. It was assumed that he could be added as a beneficiary. Question, was that good enough for his right to get information?
Well, I'm not sure it's quite fair to say it's simply assumed.
All right. Well, that's my question. I'm asking for assistance. If it was argued,
well,
can you show us where?
Yes. Let me just the argument that was being made is it's at if you look at 2411 at David Brownbill's argument. It was said, the argument was the petitioner is not and has never been the beneficiary of either trust, nor is he the object of any power under them. His father was only a member of the class of objects, and as such had no right to see the trust documents. Whatever right he had died with him and didn't pass to the petitioner, who therefore can have no personal entitlement to see the trust documents. The power to add beneficiaries was never exercised, however strongly urged it should be. It cannot, as a matter of construction, be deemed to be exercised. That's a slightly different point.
Right. So that does seem to be argument which was presupposing, well, it might be exercised, but it hasn't been, and you shouldn't assume that it has been. And then we go on to the debate about whether there's a right to the information.
Yes.
All right. Okay. That's helpful. Thank you.
But was he bringing the action in his personal capacity or in his capacity as administrator of his father's estate?
Both.
Yes, it was both. But his father actually had no rights at all. So any rights he could only.
But his father had been actually a named object.
But
yes.
It died, so he's no longer got any rights. I mean, that was the important point. I'm sorry, without taking you to it, could I also, where is it? 2433. At 2433, yes, paragraph, you mean 68.4? 68.4. Yeah, which explains that he is a possible object of very wide power and an object who may be regarded as having exceptionally strong claims. But the simple, just to go back to Lord Sales's point, I mean, the whole case has proceeded on the basis that he is somebody who can be added. So, whereas on the argument that's made before you, that actually was a false premise, because...
No, I appreciate you can undoubtedly say these are very eminent Chancery judges.
You have got to say these are eminent judges who are asleep at the wheel, that they are failing to spot, in relation to this trust, that, the way Mr. Wilson puts it, that this really doesn't work at all. And in our submission, that is surprising. Can we look at Beattie, another decision of Mr. Justice Hoffman, which is at 2365 is where it starts. And I know you've all looked at this, but this case concerned...
Could you just give me the page again?
Yeah, sorry, it starts at 2365, my lord. So this case is concerned with testamentary trusts established by Mrs. Beattie, and the default beneficiaries were the daughter and grandchildren of her late husband by a previous marriage. You can see that at 2367 G to H. Now, under clauses 3 and 4 of the deed, she gave the trustees a power to distribute the trust fund to such persons, personal persons, as they think fit. And she wrote a letter of wishes indicating whom she wished to benefit. Now, the trustees exercised the power, and you can see at 2367H that during the 2 years following her death, they distributed personal chattels to the value of about £150,000 to about 87 people, and cash amounting to 1.2 million people, £1.2 million to 50 people in accordance with the wishes communicated in confidence by her pursuant to clauses 3, 4 and B. Then solicitors acting for the residuary beneficiaries challenged the validity of these distributions. Now, the trustees, there's no suggestion that the distributions were in the interests of the default beneficiaries, the daughter and grandchildren of the previous husband, and it's inconceivable looking at the number of people that they would have been. But Mr. Justice Hoffman didn't consider that made any difference. What he said was that the duty of the trustees was to exercise their powers to give effect to Mrs. Beattie's wishes. That was the purpose for which the power had been created. And you see that at 2368 A to B. So I would suggest that's an important passage. Clauses 3 and 4 do not impose any trust to distribute the chattels or money over which they operate. That is shown by the gift over to the to residue of the property which has not been distributed within the 2-year period. They confer instead fiduciary powers which require the trustees to give consideration as to whether they should be exercised and to act in accordance with what they honestly consider to have been the purpose for which Mrs. Beattie created the power. Now, in my submission, that is a very pithy summary of our submission, that the trustees are obliged to act in accordance, when they exercise the Clause 8 power, with what they honestly consider to have been the purpose of for which the power was created.
The power itself, I think we find in Clause 4 at 2367E, is that right?
You find it in 2367, yes.
Yes, which is to allocate and pay over
among such persons
among
they
such
think
personal persons, whether individual or corporate, as they think fit.
Yeah.
Yeah.
And any part of the legacy not so allocated or paid over shall fall into and become part of my residuary estate. But yes, of course, in paying out the money, they don't have to act in the interests of the residuary estate, because if they did, they wouldn't pay anything out. So this is another example of a case where the courts recognise in our submission that you can give a very broad power to trustees here to distribute property to whomsoever they think fit, and you're trusting them, point that Mr. Justice Hoffman had made earlier. Now, Tony, no doubt, would say that because there's a letter of wishes here, that's what he calls a foundational document, and therefore relevant in ascertaining the purpose of the power. Now, we say to that, firstly, a letter of wishes is not part of the trust instrument, nor is it legally binding. But secondly, if once you accept a contemporaneous letter of wishes is sufficient to enable the trustee to use the power to benefit someone other than the individuals and objects originally identified, then why is the trustee not able to do this in the absence of a letter of wishes, but with some other evidence? This is what the settlor intended. And the answer to that, if we go to another very distinguished chancery judge, this time Mr. Justice Templeman, and that's re Manesty. That's at 2394. And Mr. Justice Temple, in this case, Clause 1 of the relevant deed identified the settlor's children, his brothers and their children, as objects of a power of appointment, and that's at 2397 at G to H. Under Clause 4A3, the trustees were given the power to add to the class of objects. That is on page 2398 at B to C. And clauses 3.2 and 3.3 of the trust instrument, which is 2398D, identified the settlor's children as the default beneficiaries. So in Tony's language, those persons, the settlors' children, brothers and their children, were the individuals identified as beneficiaries or objects in the trust instrument itself. Now, some years later, the trustees exercised the power of addition under Clause 4A3 to add the mother and any widow of the settlor to the class of beneficiaries. That made them objects of the power of appointment, which they previously were not. And that you see at 2398 D to E, the paragraph beginning by a deed of declaration. Now, the original beneficiaries contended that the power of addition, not merely its exercise, was invalid, and therefore the exercise of it was invalid as well. That argument is set out at 2399D. We don't need to worry about that. Mr. Justice Templeman rejected that argument. But the important point for present purposes is that the learned judge plainly did not think that the power of addition could only be exercised in the interests of the individuals originally named in the trust instrument as beneficiaries or objects. That's to say, the children, brother of the settlor or the brother as children. And we say that for the following reasons. If Mr. Justice Templeman had taken the narrow view of the power of addition under Clause 483, the principal issue in the case, and for which it's well known, about whether the power was sufficiently certain would not have arisen, because in reality it would have been a narrow power exercisable only to add a small set of people, or perhaps other people where this would benefit this small set of people. But if you look at 2398G, the power to add beneficiaries and to benefit the person so added is exercisable in favour of anyone in the world except the settlor, his wife, the other members of the accepted class for the time being, and the trustees, other than the settlor's brother Henry, who was one of the original general beneficiaries. This is not a general power exercisable in favour of anyone, nor a special power exercisable in favour of a class, but an intermediate power exercisable in favour of anyone with certain exceptions. And the reason why His Lordship said that the power was not uncertain was that the trustees would be guided by the concept of the settlor's bounty and give effect to his intentions. And that's why he concluded that there was no real distinction between a wide special power and an intermediate power. In both cases, the trustees were to seek to give effect to the settlor's purpose in creating that power. So if you would go kindly to 2401 at H, you'll see Mr. Justice Templeman there says, but in Gestetner, it was impossible to derive any assistance from the terms of the power, save that the trustees, it could be assumed, were expected to have regard to the considerations which might move the settlor to confer bounty on the beneficiaries. A similar expectation may be implied from an intermediate power, and in the present case, if the settlement is read as a whole, expectations of the settlor are not difficult to discern. In Gestetner, the terms of the power did not in themselves indicate how employees were to be compared with relations, charities, individuals, and other classes of beneficiaries. The terms of the power in themselves did not indicate whether and on what grounds one employee might be considered, whether by reference to services rendered to Gestetner or to the settlor, or by reference to age, health, or any other criterion. The terms of the power did not in themselves indicate whether and on what grounds one relation out of many was to be considered, whether by reference to his proximity to the settlor, poverty, educational requirements, or any other circumstances. The terms of a special power do not necessarily indicate in themselves how the trustees are to exercise the power. That consideration is confided to the absolute discretion of the trustees. And if we could go to 2403 at D, he then said, after considering the example which came from Baden about a resident of Greater London, or all the residents of Greater London, he says, a special power does not show the trustees how to consider the exercise of the power in a sensible manner, and does not by its terms enable the court to judge whether the power is being considered in a proper manner. The conduct and duties of an intermediate power and the rights and remedies of any person who wishes the power to be exercised in his favour are precisely similar to the conduct and duties of trustees of special powers and the rights and remedies of any person who wishes a special power to be exercised in his favour. In practice, the considerations which weigh with the trustees will be no different from the considerations which will weigh with the trustees of a wide special power. In both cases, reasonable trustees will endeavour, no doubt, to give effect to the intention of the settlor in making the settlement, and will derive that intention not from the terms of the power necessarily or exclusively, but from all the terms of the settlement, the surrounding circumstances, and their individual knowledge acquired or inherited. Now, all of this in our submission is consistent with our submission and is inconsistent with Tony's case based on his proposition 3, because none of this would have arisen if it were right that these powers could only be exercised to benefit the existing beneficiaries or object. The case would have been decided on the very simple ground that the power of addition can be exercised only in the interests of the settlor's children, his brother, or their children. And so, again, we say that is an important case for your lordships to consider. Now, the other case that we have referred to is a decision which we have already adverted to, but it's worth looking at. It's the Shu Pak Nin case, which is at page 7003. Now, in this case, a Hong Kong businessman set up a discretionary family trust in which his issue was stated to be the objects of a power of appointment. And you can see that at paragraph 43 on page 7019. The default beneficiary was a named individual called Po Leung Cook, which is at paragraph 49. So, looking at that, on Tony's theory, all the powers under the trust would have to be exercised in the interests of the settlor's issue or Mr. Cook, because they were the individuals identified as beneficiaries or objects. Now, under clause 26, which is on page 7020, there was a power to add to the class of beneficiaries.
Sorry, I'm sorry. Can you just show me again the class of the existing class of beneficiaries?
The existing class, yeah.
I mean, you referred to it, but I'm afraid I haven't quite caught up with it.
It's at page 7019.
Yes, and where is it there?
So, clause 3 to 7 was discretionary powers in favour of a class of beneficiaries defined as eligible beneficiaries. The original eligible beneficiaries are the settlor, and all such issuers shall be born prior to the perpetuity date.
Right.
And then
it's the definition of issue. Right.
So, and there was in this case, page 7020 is clause 26, which gave the power of addition. Sorry? Yeah, paragraph 45. And there was a letter of wishes identifying whom the settlor wished to benefit. And then if you go to page 7049 in the judgment of Mr. Justice Creswell in the Grand Court in the Cayman Islands, at paragraph 147, he said that given that the trustee owes fiduciary duties to the existing class of eligible beneficiaries, it's necessary for the court to consider whether the proposed exercise of the power of addition would be a breach of such fiduciary duties. Plainly, the exercise of a power of addition will, by definition, never be in the interests of an existing beneficial class, as their beneficial interest will be diluted.
Pause there. I mean, that can't be right, can it?
No.
Which paragraph?
This is paragraph 147.
Yes.
I mean, that sentence beginning with the word plainly, with all due respect to the judge, is plainly wrong, isn't it?
Well, in the sense that you could add someone...
You may dilute the existing class, but it may be very much in their interests that you do so.
Well,
You might add some heirs, as it were, of theirs, and it'd be extremely good news for inheritance tax purposes. I mean, there might be all sorts of reasons.
Can I say, your Lordship is right that Mr. Justice Cresswell is wrong to express it in unqualified terms.
Yes, it's just worrying when it seems to be a step in his reasoning.
Yeah, but it's wrong to put it in unqualified terms, but it is right in most cases. There could be circumstances in which there is a reason why it is in the interest of a beneficiary. But if all you're doing, in other words, my Lord, what he's saying is, if you add somebody where, in other words, there isn't that isn't intended to benefit in the way your Lordship has said, an existing
But if you carry on with the rest of the paragraph, it seems to me it's simply wrong, isn't it?
Well, I don't agree, where he says that the dilution or potential dilution of the interests of the existing beneficial class will not of itself mean that the exercise of a power of addition is a fraud on the power.
That's fine. It's the next bit.
Otherwise, it would never be possible for such a power to be exercised or to be valid in a trust context.
I mean, that's just not right.
Well, it's only not right because your Lordship, he's expressing that as it were, in an unqualified way, because there could be circumstances, which is what your Lordship is saying, where adding somebody can be in the interest of an existing person, and therefore...
Or an existing class.
Or an existing class. But in this particular case, that's not what was happening.
I mean, this seems to be the same difficulty as I had with the Lewin passage. Is this, in fact, the authority that is cited for the Lewin proposition?
It is one of them.
It is one of them, yes.
Yeah, the other case is the Tam case, which is in our written case at 1225 on page 1911, which also made the point. But the point that your Lordships push back on, with respect, you may be right, or you are right, to say that it's wrong to express things in an unqualified way, but it does put into focus whether or not the whole question, can you add people where that isn't in the interests of the existing people, and that is going to dilute the existing class, because it necessarily does. This case...
But if I may say so, if one reasons it as Mr. Justice Cresswell does here,
yes,
you then almost are into an argument, well, since the power cannot be exercised in the interest of a beneficiary, but it must serve some purpose within the instrument, then of necessity you've got a departure from the usual proper purposes rule. But if you address the intermediate stage, which the judge fails to do, then it can be exercised in circumstances where it will be in the interest of a beneficiary, and then query whether it can be exercised more widely than that.
But that then raises the question, with respect, that because what is being postulated is, well, there are circumstances in which you could add someone which could be in the interest of the existing beneficiaries, but you still have to stand back. And yes, Mr. Justice Cresswell here, because that's what he was actually looking at, a situation where you are adding people. Question is, where you have these powers of addition, is it intended that you can exercise them, notwithstanding that will dilute the interests of somebody in the existing class and is not in their interest? That's actually what everything we're saying comes back to. Did the settlor intend to tie the trustee's hands so that he can only act in the interests of the existing class, or by the power of addition, was he intending to unfetter him from the people defined in Schedule 2, so that he could, if he saw fit, change that?
But unfetter him not completely, because you have to go through processes of proper consideration.
Yes, that's part of my submission. You have to go. But
if I may, just going back to your Save the Whale example.
Yes.
I mean, at the stage of considering whether one of the beneficiaries' interest in whales is enough to justify adding Save the Whale as a beneficiary, it doesn't happen automatically. No. The trustee would have to consider whether, actually, if you extend it that far, have you diluted the trust so much that it'll have a distinct potential negative impact on the other beneficiaries at some future time, when once you've admitted them to the class of beneficiaries, maybe the whole assets of the trust can be given to them at some future time.
I don't think that is actually right, the way your Lordship is putting it. Right. If you were, for instance, it would be a very odd thing to say, when I add the Save the Whale in 2000, say, let's say this trust in 2005, that you would have to think about, well, I wonder if I add them in 2005, one of the children is very keen or has a moral obligation towards Save the Whales, I'm going to add them. I wonder what will happen in 50 years' time when I'm dead, or the current directors of the trustee are dead, what somebody else would do. I mean, you'd surely just have to look at it one step at a time. And once...
Yeah, I agree. That was really what I was
But where we part company is... I'm not saying you can't add Save the Whale because you think that is in the interests of the existing beneficiaries. I'm not saying you can't do that. But what I say is that you're not constrained by it being in the interests of the existing
No, I appreciate that's your submission. Yeah. But what I was putting to you was really about the significance of the intermediate nature of the trust structure here, that you don't immediately go to, well, someone's interested in whales, let's have Save the Whale. It's a much more considered question in which a whole range of factors would come in, including recognising that if you let in Save the Whale now, and you absolutely have the power to do so according to the terms of Clause 8, that there will be, it will open up the possibility that in future, some future trustee might think whales are a great thing, let's give all the money to the whales. And so that is one possibility that would have to be factored into what might be quite a complex assessment by the trustee as to whether to add in Save the Whale or not.
But with respect, I think we're sort of departing from what is the issue here.
Forgive me. Okay.
No, it's my fault for introducing the Save the Whale example. I mean, as I understand what your Lordship is saying to me, you can add Save the Whale if that is in the if that's in the interest of an existing beneficiary.
Yes. Which was your example? That's what you gave to us.
It's my example of showing why you get to an odd result in if that were right. That in this, all I was seeking to illustrate is you get to an odd result if you say on Tony's case, it's accepted you can add anyone, providing that is in the interests at that stage of the existing beneficiaries. The point I was making is that it seems a rather odd situation, because the submission that Tony makes is that once that person is added, then you can exercise the powers in their favour without reference to anyone else.
Yes, which is precisely the basis of the point that I was putting to you, that you might pause long and hard before you take that step. You might take that step, but you might pause long and hard before you take that step.
Well, the only point I was making is, even if you've paused long and hard on the approach your Lordship is taking, once they are in, save the whale, then on this approach, you can then further their interest to the exclusion of everyone else.
Yes.
Well, the point I was making is that that doesn't really suggest that the Schedule 2 beneficiaries are, and the Schedule 3 beneficiaries have this paramount interest, because once anyone is added, then their interests can take priority. In other words, the problem with all of this is this has got nothing to do with what the settlor intended. And in our submission, as re Beatty shows, when you exercise these powers, what you're supposed to be doing is considering what would the settlor want. And that's why the power is given in our submission.
Yes, thank you.
And the bedrock of the argument that's made, as we understand it, from Tony's written case at paragraph 67, is that the fundamental purpose of a family trust is generally represented by the interests of the default beneficiaries. Now, that, we suggest, is a surprising proposition, and the reason that's given for it is it's only the default beneficiaries who have a vested interest in the trust, whereas objects of powers do not. Now, we suggest that that is confusing two different things. What we're concerned with is the settlor's purpose in designating the default beneficiaries, not with the nature of their interest in the trust property. The fact that they have a defeasible vested interest doesn't lead to showing that the settlor's purpose in identifying them was to benefit them, or more importantly, that powers of addition should only be exercised in their interest. Indeed, the reason for designating them was to avoid a resulting trust at the end of the trust period. And the expectation that the default beneficiaries will not actually get anything from the trust. And your Lordship asked yesterday...
That may sometimes be the intention of naming the default beneficiary, may merely be to stop there being a resulting trust and without the intention. But presumably there may be family trusts where it's clear that the intention was to benefit the default beneficiaries. If there's a very narrow power of appointment, or if the trust is not lasting very long. I mean, is it always the case that you have to disregard the identity of the default beneficiaries?
It's absolutely not always. It's a question of looking at the particular terms of the trust.
So what is there here in Schedule 3 that makes you say that they're only there to stop there being a resulting...
Generally, the reason you have to... why do you have default beneficiaries? The reason you have them is because if you don't have default beneficiaries, there would be a resulting trust right at the outset for the settlor, although the dispositive powers wouldn't be invalid and could still be exercised. And we've cited the authorities for that in our case, footnote 118, page 1909. But so, if you look at this particular, the point is this: if you take the case here, or you take Schmidt, any of these cases, the expectation of the settlor is that the powers that the trustee is being given will be exercised, and the trust fund will be distributed during the course of the life of the trust. If you look at all these cases, that's I mean, that's the idea of it. The idea is not that the trustees are not going to exercise their powers. I mean, for instance, the sofa case, which we...
Yes, I can see in the sofa case that clearly was. The question is this a case like the sofa case, or is this a case where actually one can't say, looking at who the beneficiaries are, that it was not intended that they would actually get any benefit?
Well, the thing is, I'm dealing with a proposition that is being made where you have default beneficiaries. Necessarily, as a matter of law, those people are to be treated as being the intended, the settlor is taken to intend that they are the people who will benefit. And the point I'm making is just because you have a default beneficiary, that doesn't follow. That their interests represent what's called, by Tony, the fundamental purpose. We say that's the non sequitur. And the objects of a dispositive power are in a different position in that they don't have a vested interest, but the reality is that they are likely to be the individuals who are expected by the settlor to benefit from the trust. Now, suppose a settlor creates a power of appointment for X and Y, but does not give any power to amend or add or exclude beneficiaries. That's like the Thatcher case. Then it's fair enough to say the settlor may well have intended that X and Y alone should benefit from the trust, although even that would depend on the circumstances. But if you create a power of appointment for X and Y, whilst also giving the trustee the power to replace X and Y with A, B, or C, then we say just because you originally identify X and Y doesn't mean that they are the only people who the settlor intended to benefit. Indeed, you say it's the opposite. Yeah, and the Lionel Smith in the article, which I think a lot of reliance is placed, at 2962, yeah, says that in the bottom of the right-hand column, that where he says, as in the Red Cross Trust, the expectation in this family version is that the trust property will be distributed by the trustees pursuant to their wide dispositive discretions rather than via the default clause that identifies the residuary or default beneficiaries. Now, the only difference between the Red Cross case, I mean, if you take the Red Cross case or Schmidt, where I think it's the RNLI, it's fairly obvious that the settlor hopes and intends that the trust funds will be distributed and not go to the default beneficiary. That doesn't mean it's a sham. It means that they hope and expect that the settlors will exercise their powers of distribution during the life of the trust. You don't set up a trust with the intention that things go in default.
Can I just ask, how would Saunders and Vautier work in that situation? Wouldn't you need, if you did want, if the beneficiaries did want to collapse the trust using Saunders and Vautier,
yes,
you'd have to bring in the default beneficiaries as well as the, if you like, wide discretionary class of beneficiaries, wouldn't you?
That's right. Yes, I think so. But
right.
The default beneficiaries can't collapse it.
So, I mean, doesn't that show that the default beneficiaries really do have a real form of interest in the beneficial interest in the property?
Well, but the default beneficiaries cannot themselves collapse.
No, of course not. You need all the people who have the beneficial interests to work.
Well, they have a vested, defeasible interest. I mean, it doesn't make any difference whether your default beneficiary is Red Cross or the Children in Issue. they have the same defeasible interest. But the reality is no one expects that you will ever get, that they will ever actually acquire anything, because it's expected and intended that the trustees will distribute the trust property during the life of the trust.
Yes, thank you.
Yeah. Yeah.
I mean, everything on your submissions turns on the settlor's intention, as I understand it. You're trying to work out the purpose, and you say that rests on the settlor's intention. There is no legal rule that requires that it's always got to be used for the benefit of the beneficiaries.
Exactly.
In working out the settlor's intention, are you confining yourself to contemporaneous documentation about wishes and the like, as well as the trust deed, obviously, or are you accepting that one might include, or is your proposition that one might include subsequent documentation?
We need to separate out different things. If one's asking oneself, what is the purpose of Clause 8 and purpose of the trust deed, that all has to be decided by reference to the trust deed itself and the admissible background material to the trust. So I'm not saying that the settlor can come along several years later and say, I gave you this power, and even though it doesn't, one might say it doesn't mean this, he can't unilaterally come along and say, actually, I think it's a power to do this, and that's what you must do. He can't change what he's done. But where letters of wishes and changing letters of wishes comes into being is that where you give a trustee a discretion, take the simple position of exercising a power as to who you're going to distribute. You've got a whole class of beneficiaries. Who am I going to give it to? At the beginning, you may get a letter of wishes. The fact that the settlor 5 years later says to you, let's say at the beginning he says, I like John, he's a jolly good fellow, and I hope you're going to look after him and his family. He may come along and say 5 years later, well, I now think he's not behaving very well and they're not very deserving. Now, you don't have to do what he said. It's the sort of thing that you are entitled to take account of. And the reason for that is that you're not changing anything, but you are, at the end of the day, as trustee in that example, distributing the bounty that emanates from the settlor, and if he's got some relevant information, then you're entitled to take account of it. But he doesn't have any right to say you should do this or do that, but he can tell you what it is, how he thinks it should be done now.
I mean, doesn't this just go back to the difference between point A and point C in the Winston Holtz analysis? I think it's paragraph 168 of the Court of Appeal. Mm-hmm. So you have the construction of the term, which, if you like, is a hard boundary. You have to stay within that hard boundary. But then at C, you also have to exercise within that hard boundary the powers for proper purposes. Yeah. I think what you're saying is, at the first stage, you focus down on the usual aids to interpretation of an instrument at the time that it's made, i.e. contemporaneous and part of the factual matrix. But insofar as one's considering exercise of discretion within the hard boundary of the power, you may be able to look at subsequent wishes of the settlor as being relevant to the discretion you have to exercise.
And I would say that is actually coming in at the deliberation stage. It's not actually the proper purposes.
All right.
I mean, well, you can consider. I mean, it's actually coming in as you're at the adequate deliberation stage.
But I don't think that the appellants were saying anything different from that. I think that the difference between you is the degree or the nature of the extent of the change that can be made within what's said to be the initial purpose of the donation, of the settlement, because I thought you said at the beginning, yes, this was intended to be a family trust to incentivize them, to give them some money, not a lot of money, but some money, but then unforeseen circumstances occurred, they had to hold on to the shares, and then they wanted to just completely change it. But I don't see how then you can ever have a purpose, because if you said to any settlor who gives money on an irrevocable trust, well, is it your intention, though, that if everything changes beyond anything we could possibly foresee now, you might want to completely change your mind about what happens with this money? The settler's always going to say, well, yes, of course. So the purpose initially always incorporates doing something completely different if the circumstances are completely different. Well, so how do you ever get some kind of settled purpose?
Well, the settled purpose, I mean, you've got to remember, it depends what purpose of what we have to do, has to work out. We're talking about the
purpose of settling this fund on these trusts.
The purpose of settling the fund on these trusts was to set up a trust which was intended to provide a means for incentivizing the 17 children, but with a proviso that if circumstances changed, then the trustees would have a discretion to decide on who should receive the bounty. That's, I mean,
and who decides whether the circumstances have changed?
The trustees. The only people who can decide that are the trustees. I think your question is premised on saying it's for the settlors to decide. It's not. No one is suggesting that. It's for the trustees to decide that.
So the trustees can always subvert the initial purpose of the settlor if, in their view, reasonably arrived at, the circumstances have changed completely.
Well, they won't be subverting that. I mean, with respect,
diverting then. To
but they won't be subverting or diverting, because the I mean, I understand your ladyship doesn't agree with me, but the simple point is, on our submission, is that Clause 8 is intended to give the trustees the power to deal with circumstance. So, with respect, it's very difficult to see how you can say exercising the power that you've been given by the settlor is subverting or diverting what the settlor has intended. Now, your ladyship may say, no, I don't agree with you. It gives that power. But logically, if it does give the power, then what one is doing is what the settlor has said he's prepared for you to do.
That all hinges on the use of the word any in Clause 8.
Well, no, it doesn't. I know your lordship has said
where
that.
else do you get it from?
Well, you get it from the deed as a whole, Clause 8 in its context, the deed as a whole, and the background. But also,
there's nothing in the background to support that, is there?
The background about how the trust is set up.
Yes.
Then you have a trust with this broad...
But I'm sorry, where in the background do we get the settlor's intention that the trustees would be able to completely change the nature of the trust in changed circumstances? Where in the background do we find that?
So if I can answer, what we're saying, and the Court of Appeal accepted, is one of the points we make is why do you give people these powers of addition? And I took you to, I think, what Mr. Justice Briggs said in the Stenner case, which is to deal with unforeseen circumstances, changes of circumstances. Now, that's, if you like, the dividing line. If one says, well, no, that's not what it's about.
There can be changes of circumstances and changes of circumstances. So there could be plenty of changes of circumstance which make it appropriate to expand the definition of beneficiary without completely terminating it as a, quote, family trust and substituting something completely different. So you really, I mean, yes, change circumstances, I don't have a problem with that, but I haven't seen anything which suggests that the settlors here, the economic settlors, intended to confer this power to go to the altar
what
the
they
nature of the
intended
trust?
to do, surely, the answer to that surely is they intended to give the trustees the power that one sees in Clause 8.
I mean, it comes back to Clause 8.
Yes, it does. But, I mean, and Your Lordship's saying, well, it's all just on the word any. I mean, it's looking at Clause 8 in the context of this and Schedule 2. Schedule 2 says these are the beneficiaries subject to the exercise of the powers of Clause 8. Clause 8 says, I know Your Lordship doesn't like it, but it says you can add any person.
I mean, I don't. It's not a question of liking it or not. I mean, I think it has a perfectly good meaning, which, as I've suggested, is it identifies.
It identifies.
There's no limit on the identification.
But there's nothing in the trust deed which says this is limited to, and then to limited to only benefiting these people. So one has to find something else which leads to that conclusion. And what we say is you don't find that, in that I mean, other than on both sides, you have to ask yourself, what was the purpose? Was the purpose simply a rather minor clause in reality, which is just, well, as things go along, maybe we'll need to add people because family relationships change, and that's all it is? Or was it intended to be potentially that, but also potentially more whole-scale? And what we say is that it's not intended to just deal, and it's very difficult to define the limited circumstances. And once we would suggest the fact that it is difficult suggests that it's actually intended just to be a broad discretion where you've left it to the judgment of the trustees, just as you have in, say, a rebete case, where you say you can distribute and manisty to anyone effectively. You've left it to the trustees' judgment. Now, one of the points I wanted to pick up, and I know Lord Burrows had asked me about it, is I think the suggestion that if you have a trust which is wide in this sense, that is potentially invalid. Now, the invalidity argument, as I understand it, is well, let's take it in stages. It wasn't suggested below that the GRT trust is invalid if it's construed as we construe it. Now, it's now been raised, but if there were something in the point, the appropriate remedy would be to challenge the validity of GRT. Now, what is sought to be done is to use the spectre of invalidity to persuade you to attribute to the GRT trust a meaning we would suggest it cannot bear, and to attribute to the settlor an intention he didn't have. And take a case like Sofa as an example. It's plain that Mr. Sofa didn't intend Freshfields and CMS to be the objects of his bounty. Now, I can see if on the other side's arguments they say, well, a trust which operates in the way that may have operated, they want to say was invalid. But that wouldn't be a basis for imputing an intention to Mr. Sofa that in a trust which names Freshfields and CMS as respectively default beneficiaries and I think objects, that he's intending to benefit them. I mean, plainly he wasn't. And so an invalidity argument can't be used, as it were, to change to treat the settlor as intending something that he didn't. Now,
sorry, I'm just not quite following that. I mean, if someone's been named as the residual beneficiary, they are intended to be benefited if you get down to a residual situation.
They're intended, sorry, I didn't express myself clearly. Okay. They're intended, I mean, you take the Sofa case, you intend to name whoever it was, the partner at Freshfields, as your default beneficiary. So you do intend, as you say, if you ever got there, that they will receive the trust fund. But you do not intend that you should ever get there. And
you don't expect that.
You don't expect to. You don't intend to. And indeed, I mean, and where does that lead? It would then be very odd to say, when you have a power of addition in SOFA, for instance, to say that you've got to exercise it in the interests of the existing default beneficiary, or indeed they're the objects named in the trust, who are, when you don't actually intend any of them actually to be the real beneficiaries, as Lord Walker, I think, put it in Schmidt. That's the only point I was making. But if it's said, well, that would render the trust invalid, we don't accept that's right at all. But if it did, it wouldn't lead you to say, well, OK, I'm going to treat this as a trust where the settlor must be intended to benefit Freshfields and CMS. That's the only point we were seeking to make. Now, the next point I want to just address briefly before I see the time. I don't know whether your lordship's...
If you've got a brief point, you can address it, because you started slightly later than planned.
Yes. My lord, there's the suggestion that's been made that there's no trust without what's been described as the irreducible core of obligations owed by the trustees to beneficiaries and enforceable by them. And reference has been made to Armitage and Norse for that proposition. Now, what that doesn't lead to is that every power in a trust has to be exercised for the benefit or to advance the interests of the existing beneficiaries. And indeed, as I understand it, Tony accepts that isn't the case. If on the true construction of a power, you don't need to do that. And we would suggest that the suggestion that the irreducible core requires that you can only operate in the interests of existing beneficiaries is contradicted by cases such as Schmidt, Manistee and Beattie, and other cases along those lines. And the irreducible core is not infringed by the existence of a power such as Clause 8, because until a beneficiary is removed, the trustee owes fiduciary duties to him. And in any event, as Schmidt shows, duties are owed, and the trust is enforceable by not only objects, by people who can expect to be objects. That's exactly what the point was, we suggest, in Schmidt. Lord, that's probably a good spot to finish tonight. Yes. Would it be possible for us to start slightly earlier tomorrow, like we did today?
Or? Well, same as today, 20 past.
Thank you.
Is that all right with my colleagues? Yes. We'll do that. That will give the respondents a full half hour from 12:30 to 1. The appellants. That you finish by 12:30 then, would that be right? Or are you proposing to finish slightly earlier?
I wasn't proposing to finish earlier, no.
Not proposing to finish earlier?
No.
Okay. Well, I think that would be a fair allocation of time. The court will now adjourn.